Quite started. There we go. Now you got the wording. All right, welcome everyone to this roundtable session on caseload, caseload standards for PDs, hosted by IDRA, but put together by Sarah Gamble. So thank you for doing that. We will have we have a set of panelists here. Thank all of you for agreeing to do so. And we'll kind of introduce ourselves at the beginning. But then we are going to have a kind of structured discussion for the first portion, and then we'll have a pretty big block of time for kind of less structured discussion and questions at the end. I think for like quick questions, we can kind of do those as they come up, and we do have a lot of people in here, so if you can just do the hand raise thing, then we can address that way. And then yeah, the more substantive stuff we'll probably talk about at the end. But then I'll pass it over to you, Sarah.
All right. Well, good morning, afternoon to some. Thanks to IDRA for putting this together. I'm Sarah Gamble. I'm the research director at the Texas Indigent Defense Commission. And we were interested in putting this panel together because, and I will let my colleague Wesley go into a little bit more detail, but we are in the middle of trying to understand, what we are going to do in Texas in regards to caseload, our caseload guidelines. And so this, Torrin said, we're going to go around the horn. So I'm going to pass it over to Wesley to introduce himself. And he's going to also introduce a little bit about what the system looks like in Texas. So let me get the slide pulled up, Wesley, and
Sounds
take it away.
good. Thanks, Sarah. My name is Wesley Shackelford. I'm Deputy Director at the Texas Indigent Defense Commission. And the quick snapshot on Texas, we are a county-based system for indigent defense. Our organization, TIDC, does provide some grant funding. About 10% of the total spend, 90% is county funded. We have a mission to improve indigent defense and as well as some oversight authority, including to set standards. And one of those areas that was called out is caseload and workload standards. So that's obviously what the focus of this is going to be about in just a few minutes. At the county level, the systems are provided through traditional ad hoc assigned counsel in almost every county, but one of the big value adds that has happened since TIDC was formed is we've created a bunch of public defender offices now serving 84, so about a third of our counties. Contract systems still exist in some counties, especially very rural counties. And we have about 9 counties served by managed assigned counsel programs where the defense function is managed by a chief defender. It's taken out of the judge's hands effectively to manage the appointments, the wheels, as well as the vouchers. So that's the thumbnail of Texas.
All right. Pass it over to Torrin. You are muted.
Thank you. At the beginning of these meetings, there's always slightly too many things to look at. But yeah, so I'm Torrin Liddell. I'm here as as a board member for IDRA, but I'm also on this panel. I work for the Indiana Commission on Court-Appointed Attorneys. Oh, I realize I have animations into here. You can just go until it's full, sir. So we are a state level agency in Indiana that we're the only agency that kind of provides oversight on public defense at the county level, which is the primary way that public defense gets delivered. So we provide reimbursement, and we also set standards to receive that reimbursement. Participation is voluntary. So that means that, a lot of that's kind of the baseline for a lot of the conversation we're going to have here, where, we make choices that maybe we wouldn't make if the counties didn't have the option to just kind of take their ball and go home. If you do agree to participate, you get a 40% reimbursement excluding a few things, but it's roughly 40%. I know you probably can't read the map because it's really small, but this is just to give you an idea. The green is the stuff that we cover. The white is the stuff that we have no relationship with, and then the orange are the counties that are they do send us data as part of the Title IV e-pass-through program because we are a pass-through agency for that, but they don't participate in reimbursement, so they don't have to follow our standards, but we do have some data from them. And then Lake County up near Chicago is a weird one that kind of got grandfathered in where their adult criminal is in the program, but the rest of the county is not. So it's kind of a weird half member. But so we cover, including Lake, 70 of the counties are part of the reimbursement program, and then there's an additional 8 that are in the 4E only program. And this is actually, we had a new one join, Marshall, that one up at the top that's orange is now green. They just joined. So good news. We cover adult criminal, juvenile, family court, mental health commitments, basically anything that a court could appoint an attorney for except for GAL work that is excluded from the program. So all the other stuff we cover. And yeah, I think that's the important stuff. So I'll pass it on to Alyssa, right?
Yes,
Right.
Alyssa from New York.
Yes. Hi, everyone. My name is Alyssa Clark. I am a supervising senior research associate here at the New York State Office of Indigent Legal Services. Here in New York, we absolutely love attorneys, which means we use a lot of words to describe things. So I apologize for that very wordy introduction. So first, I'm going to just say that how our service is delivered in New York State, and we love our statutes here as well. So there is a statute under County Law 18B, Section 722, that allows or that requires counties to create an indigent defense plan using one of the 4 models that you see below. So you can either have representation by a public defender office, a legal aid society or bureau, a bar association plan. We call those assigned counsel programs or ACPs, but the official language is bar association plan, or you could have a combination of the previous 3 options. Next slide, please. So how it looks in New York right now is we primarily have a bunch of counties that have public defender programs for their criminal primary office. As you can see from the pie chart below, I know it's really small, but we have approximately 3/4 of the counties in New York that have a public defender office as their criminal court primary provider. Next slide, please. We then have a second level, which is like the conflict system. We have in New York a system of conflict defender offices or assigned counsel programs. As I'm sure many people here on this call know, a public defender office or legal aid bureau can't accept every single case, and so there has to be some type of conflict. This is what the conflict system looks like. So here we have the conflict defender offices and assigned counsel programs, and then we broke it down into managed assigned counsel programs where there is an administrator who oversees the day-to-day functions of the program, and then what we call just ACP only, which means that the judges make assignments and that somebody somewhere in a county office makes sure the attorneys get paid. And as you can see, I believe below, we have most of the counties here that are just the assigned counsel program only counties. So those are the counties, like I said, where the judges are making assignments and it's going through some type of county office. Next slide, please. So the role of the New York State Office of Indigent Legal Services, obviously we don't provide direct representation to clients throughout the state of New York. What we do is we first identify the state funding that's needed, and we take that to the governor and legislature, and we do our best to ensure that funding is appropriated each year. We have been much more successful on the criminal side. We have a statewide expansion that's over 250 million. We have some statewide settlement counties that I will be referencing a bit later that are receiving their own portions of funds, and we are currently trying to beef up that family court funding. Once we get that money or we ensure that it's going to be appropriated, we disperse the funding through county plans or budgets. We have a set or many teams of attorneys here that work with the provider offices in each of the counties on how they are going to reach the tenets of quality representation. We also develop standards. So we have assigned counsel standards, public defender office standards, caseload standards, quality standards, conflict defender standards. There's many standards. And then after that, we obtain data and information from counties. And then my team, the research team, we analyze the data to identify what is working, what's not. And then we work with the attorneys in our office to say, okay, this is working. So how can we make this happen in other places? And then those findings are usually publicized through agency reports that go to the Division of Budget to make sure that we know we're doing what we said we were going to do, and to the executive branch. Those are usually available online as well at our website. And I think we said that Jonah was going to be next. Or yes.
Actually, we're going to go to Matthew next. So we're going to go coast to coast. So Matthew Sanders from King County.
Happy to go. Morning, folks. My name is Matt Sanders. I'm the director of the King County Department of Public Defense. As the name tells, we're county-based. We serve roughly 2.3 million residents. The county spends somewhere in the range of $100 million annually to support DPD. What do you get for that much money? Because that number is going to continue to rise. Is our staff is roughly, it's over 500. So it's, we're moving up. That is roughly 250 lawyers, 40 supervisors, 80 investigators and mitigation specialists, as well as a director's office with a director of data who we're trying to hire now, CFO, HR, all the things that you would expect a department to sort of have as like sort of operational needs to service their needs. In terms of what we do in-house, we have 4 law firms and then the director's office. And so that allows us to keep most of our cases in-house, which is what we want to do, because there's supervision, there's more oversight, it's more it's more affordable. And so we're able to keep most of the cases in-house. We use a case-weighted credit model under which cases are assigned, pretrial cases are assigned a credit value ranging anywhere from 1 for your sort of low-level felony offense, a Class C is what we would call them in Seattle, to 8 credits for a life without the possibility of parole, premeditated murder charge. And so people are assigned cases that have these credits, and then they're capped at 100. Right now, as of June 24th, attorneys in the felony unit are capped around 99.7 or 100 credits. And so once they hit their, luckily we haven't had anyone reach their cap, but it's all built on this presumption that folks are going to work 1,650 hours per year. It subtracts for vacations, holidays, the things that people have to do during a year. And so we take that 1,650, we then divide it by the credits, and so in this case 100, and then we have our presumptive hours per credit, which in this case would be 16.5. And so we presume that, and that's how we sort of allocate work. And if the case gets transferred, because people have to put their time in, there's a debit and credit, so whatever work was put in, that person keeps, and then the new attorney receives whatever remaining credits on that case. We're actually right now we're revamping our credit policy. Happy to share it once it's done in the next couple of weeks. And that's it.
Thank you, Matthew. And we're saving, of course, the best for last, Jonah.
That's very silly. Hi, everyone. My name is Jonah Siegel. I am the research director at the Michigan Indigent Defense Commission. A lot of repeats from what other folks have said here, and some differences. In Michigan, we are a state level agency that sets standards, provides funding, and oversees the delivery of services by our 120 local systems. We are not voluntary, so unlike Torrance system or Torrance State, we are mandatory. We exclusively focus on adult trial level indigent defense. We have a whole separate agency that does appellate work. And then we are hoping that youth defense will move under our umbrella in the next year. It's been held up in the legislature for the last couple of years, but we hope that it will move in the coming months. For our latest year of funding, the state funded 87% of indigent defense costs, and the local system is funded 13%. So we are very heavily state funded. And up until 2019, there were 0 state dollars going into indigent defense in Michigan. So it's been a huge shift in the last 7 years. We have just over 30 public defender offices in the state. And so most of our cases are still handled by roster attorneys, though that number of public defender offices has also grown dramatically as funding has increased in the last 7 years. So I think we went from 9 public defender offices to over 30. So there's been a huge increase, but still most cases in the state are handled by roster attorneys. And I'll just leave that high level description there.
Okay, great. Well, we're going to dig into our kind of 4 main questions. The first is, and we'll start with Texas. Why are you addressing caseloads? And then we'll just same order, go around, answer the same question. So go ahead, Wesley.
Sounds good. Thanks, Sarah. We're addressing caseloads because our board has asked us to, and I think that's really based on the assessment that we have too many attorneys with caseloads that are too high. So one of the nice things that we do have in Texas is we collect data on attorney caseloads by attorney. So we see annually how many cases every attorney in the state who's handling appointments has disposed by case type. And so we report that out, and the figures they've been incrementally increasing. And so our board directed us to create a work group to come up with ideas to address it. And that group has met once in earlier this year. It's got public defenders, managed assigned counsel directors, judges, court administrators, as well as our county organizations who right now are charged with funding the system largely. And so we're looking to see, and our directive is to see what approaches are taken in other jurisdictions, which is why Sarah had the great idea to submit this panel to hear about other states that have tackled this more recently and get ideas from them. We could potentially bring back a caseload standard or a workload standard that the board could adopt. They have rulemaking authority over caseload. So the other thing that we have going into this process is we do have caseload guidelines. So we it's been 8-10 years ago, we did a series of weighted caseload studies using the Delphi method with our partners at Texas A&M's Public Policy Research Institute. And so we do have established guidelines for criminal appointments, juvenile cases, as well as criminal appeals. So that's basically where we're at in Texas right now.
Yeah, I'll go ahead. Mine is pretty short. So we've just to introduce, all of us are kind of coming at this from a different temporal angle, where Texas is kind of just starting. Indiana did this. It was a many years process, but like starting in like 2018 or something like that, and it essentially has been completed. Although we're always hoping to improve things, but right now there's no plans to make major changes in the future. So we address this because for the entirety of the existence of the commission, there was a caseload standard that member counties had to meet, but it was based on the NAC standards, the 400 misdemeanors, 150 felonies, I think. And so and then as we kind of added on more case types like delinquencies and chins and terminations, which are like family court stuff, there was just kind of an analogy to, well, like this takes slightly longer than a felony or something like that, and so then the number gets adjusted there. So there was a hope to have more of an evidence-based justification for the caseload standards that we have, and also to bust up some of those categories so that they made a lot more sense, not just have like treat murders and our lowest level felonies the same. So it had been kind of in the air at the commission for a significant period of time before some things kind of brought it to light, or brought it into focus, and so that's when we started it. I'll pass it off to Alyssa.
Okay, so in New York State, I will be referring to everything pretty much as criminal-based or family-based. So going forward with criminal, criminal court, there was a commission report that was issued by our former chief judge at the time. It was 2006. That had concluded that the indigent defense system in New York State was severely dysfunctional and also structurally incapable of providing effective legal representation. Those conclusions were based on a report that the Spangenberg group had done right around the same time. It was a 2-year study. And the Spangenberg group had actually stated that one of the biggest flaws in the New York system was that attorneys had overwhelming caseloads and or workloads. At that time, they were using the NAC standards that Torrin had referred to. Right after that report happened, there was a huge lawsuit in New York State called Harrell Herring versus the State of New York. That was in 2007. And about 7 years after that initial filing, so in 2014, the plaintiffs of that lawsuit in New York State reached an agreement. And the provisions of that agreement, and I'm reading straight from the settlement here, are that New York State will set caseload standards that would substantially limit the number of cases any lawyer can carry. And New York State must hire sufficient lawyers, investigators, support staff to ensure that all poor criminal defendants have lawyers with the time and support necessary to provide quality representation. And I want to make sure that we all understand the two biggest highlights here. Number one, that they said we were going to have caseload standards. And the second was that there was funding committed to implementing those caseload standards. It's one thing to just say we're going to have caseload standards, but it's a completely another thing to not have money to fund those. And so when that lawsuit happened, we had contracted with the RAND Corporation. I think I saw Nick Pache on here. He was actually one of our lead researchers at that time. And we had produced New York State specific caseload standards to which our counties are still following to this day. Although these standards originally only focused on the counties who were subject to the lawsuit, the provisions of this lawsuit were expanded statewide in 2017. So we went from only 5 counties having to follow these caseload standards back in 2016 to the entire state in 2017. And in addition, the state did commit funding. They committed about $250 million across the board for all of these counties to be in compliance with caseload standards. Now we turn to family court, which is a huge thing. As I'm sure you've said, or you're thinking in your head, $250 million, that's a lot of money, but it only applied to criminal cases. And so you're creating essentially this bifurcated system of criminal court and family court caseload standards. Well, in 2018, our former chief judge at the time, Chief Judge DiFiore, established the Commission on Parental Legal Representation. And the goal for that commission was to examine the current state of representation in family-related matters and to develop a plan to ensure quality representation moving forward. So the chief judge of our state is actually our board chair for our office. So they actually have the authority to kind of set agendas for our office as well as do their chief judge things. So we were instructed by our board chair, the chief judge, to collaborate with the Office of Court Administration to collect data and examine caseload standards. So in 2019, we had contracted with a group called WRI, and we created caseload standards for family court. However, of note, there was no lawsuit for this. It was just the chief judge's project. There was no expansion money that happened, and there's no oversight or commitment from the state to implement these standards. So we have them, but we are kind of at a loss of sometimes how to implement them without the funding. So I will kick it then to Matt.
Thank you, Alyssa. And so I think the short answer for why we did it is because we were feeling the consequences of the public defense crisis. COVID was hard on everybody, particularly public defense offices and the people we represent. And thankfully, there was a lot of lobbying from public defenders, folks who are stakeholders in that community who lobbied. And there's a long history, but the short version is that the WSBA basically adopted new caseload standards. And these caseload standards were informed, at least, by the landmark National Public Defense Workload Study from 2023. So that came out in 2023. The WSBA adopts new standards that basically adopt the sort of case weighting methodology that is so integral to modern practice, you know, actually recognizing that murders, and with all the video and all this other stuff, it just takes longer to do the work. And so the WSBA adopted it. But to Alyssa's point, like, that doesn't have teeth, because our Supreme Court creates the court rules, and you need actually the money to give the stand. Otherwise, people are just going to cut off cases. People are going to be refusing, and that's not good for anyone. And so around this same time, the Supreme Court then issues a series of orders, and the final order came out in December of 2025, adopting new caseload standards. Now, they differed from the WSBA in some ways, and they were similar in some ways. For the purpose of this conversation, the big difference was that the WSBA standards started implementation in July of 2025 and called for 3 years to get to the new standards. The Supreme Court, by contrast, started in January of 2026 and gives counties more time, up to 10 years. It's a debate. And so, but that's the court rule now. And so now people have to budget toward that. Historically, Washington State does not contribute a lot toward public defense. There's currently a lawsuit with Washington State Association of Councils, of Counties, suing the state for more public defense funding, because, as you can imagine, local governments are having to pull from their general fund to meet this new mandate. We actually recently intervened in that lawsuit as well, because we wanted to make sure public defenders and their offices had a seat at the table. But ultimately, in King County, the council just 2 weeks ago, seeing this fiscal cliff with the WSBA standards, and that's what we were following, adopted changes to the code that basically put DPD on the Supreme Court standards. And so, like, that's a whole conversation, so I'll spare you. But the advantage that we do have is that the county recognizes that it's a mandate. The court has said this is the requirement, and so now folks are sort of scrambling and figuring out what they're going to do to add additional funding, to bring in the lawyers, or to reimagine maybe some practices from the PAO that could also sort of impact the cost. And so, yeah.
I think I'm up. Are you finished, Matthew? Yeah. Okay. Okay. So I did make 2 slides to just walk us through this. I think, you know, I wasn't sure who was going to be on the call and where everybody was going to be in terms of thinking about this, not on the panel, but, you know, but other folks. So I went just backwards a little bit to give everybody the background for how we got here in Michigan. So we have a long history of attempts to reform Michigan's indigent defense system, which has over and over again been found to be constitutionally inadequate, and previously also among the most poorly funded in the nation. There were many attempts that, you know, to reform the system that really made only incremental progress over time. Michigan's system was described using phrases like a patchwork quilt to a train wreck. And so, you know, this has really been going on for a long time here, as I'm sure it has been in other states as well. A couple of kind of key moments that led to change. In 2002, there was a core group of criminal and juvenile justice professionals who formed what was called the Michigan Public Defense Task Force. That task force developed a model plan for the state's indigent defense services. From that, in 2003, the State Bar of Michigan adopted a resolution that encouraged the legislature to establish a commission with the responsibility of investigating indigent defense services in the state and making recommendations for improvement. In 2007, there was a class action lawsuit against the governor for failing to provide adequate services to indigent defendants. And as a result, the Michigan legislature commissioned the NLADA to conduct a year-long study of indigent defense services in 10 representative counties. Sarah, on to the next slide, please. The findings were not surprising. The NLADA found that Michigan fails to provide competent representation to those who cannot afford counsel in its criminal courts. This is a report that is referenced in Michigan all of the time. It made huge progress at that moment in time and continues to really underscore the changes that we've made. And so, this report looked across the board at everything, and there were recommendations across the board. But one of those was that attorneys were at the time were routinely carrying workloads far beyond those recommended by the National Advisory Commission, which also is not surprising because there was no binding caseload standards for public defense attorneys at that time. And so that's kind of the why. And then I will wait till the next part to move on to the what their response was to that. So I'll pause there.
Okay, great. Thanks. We're going to move on to our second question, which is the how. How are states, counties, how is everyone addressing caseloads? And no offense to the state of Texas, Wesley, we're going to move on to Indiana because we're just getting going. And so we are grappling with the how, and it's why we're grateful for this insight from other states. So, Torin, we're going straight to you.
Sure, yeah. So ABA and primarily, I think Steve Hanlon. This was before my time, so I'm somewhat speaking on base of what I've heard. Kind of came to the commission with a plan of doing a Delphi study, and as I said, it was something that the commission already kind of thought was necessary and didn't really know how to pursue. Whether they were thinking a Delphi study, probably not. But I think coming with a method was something that convinced them that it would be a plausible thing to do. And so that's how it went forward. There was a Delphi study done over a couple year period, in addition to a bunch of surveying of existing caseload and existing data that we have, which was found to be pretty inadequate. I wouldn't be surprised if some of you have glanced at the report that came out of this, but I would be very surprised if many of you had read the entire thing. It's quite long, but one of the conclusions is basically we aren't able to make any judgments about the capacity that currently exists in Indiana, just because we don't have, no one has enough data to make that kind of judgment. So regardless, we use this Delphi method. The commission itself is kind of it's a judicial-ish agency. It's technically in the judicial branch, but it is not under the Supreme Court, and it has people from the legislative and executive, or appointed by the legislative and executive branches on it, and they typically also tend to be members of those branches. So it's kind of a full government commission, but it located in the judicial realm. That Delphi method was used by that group to to come up with some kind of compromise between what we're currently doing and what those Delphi recommendations were. So the Delphi recommendations were, for the most part, more stringent than the current standards, which is not surprising. But there were a couple places in Shin's termination, they ended up being about the same. They weren't identical, but roughly the same. And actually in appeals, they ended up being like significantly more, like allowing more cases than the current standards had. So the final version that ended up kind of being a compromise between what the old standards were and what the new standards recommended, including in the case of appeals, like the amount that those were adjusted up was significantly less, because I think we also did some kind of follow-up meetings with the people on the appeals panel and stuff, and it seemed like they're in appeals especially, there's attorneys that just do appeals, and a lot of those were on our panel, and then there are attorneys that do them a couple appeals a year, and it kind of came to the conclusion that maybe the standards we shouldn't impose the standards of the people that are like really good at appeals on the vast majority of appeals that get done, which are not those people, unfortunately. So we set up those new standards. There was a multi-year rollout on those standards where we kind of kept people apprised of, on the new standards, this is what your attorneys would look like in terms of their compliance with our current caseload standards. But we're only evaluating on the current ones, but we'll just let every quarter, like, this is where you would be at, and kind of let people higher up as needed. I will say the change wasn't drastic. It's difficult because we completely spread out the felonies, for instance, is now, way more categories. It used to be two, and now it's uh five or six, depending on how you count it. Um, and so it's significantly different that way. So it was difficult to do like a one-to-one, like here's how many more attorneys you'll need. But because we had all the information about like the types of cases you typically got, we were able to like do an estimate. And our estimate was somewhere between like a 10 and 20% increase in the number of attorneys you would need, or put another way, like a 10% decrease in the amount of cases that you could take. It's not exactly one-to-one, but yes. So it wasn't a huge change. Obviously, in a perfect world, we would have just matched those caseload standards as recommended by the Delphi study. But as I said at the beginning, they had the option to leave. And given that we pay 40%, it doesn't take, if we say hire twice as many lawyers, then for sure they're going to leave, right? Because we're only paying 40%. They could get it cheaper by just keeping what they currently have and getting rid of our money. So nobody left as a result of the changes, which I think is a positive. And in fact, our membership has only increased since then. So I think it's, it's a good compromise insofar that it definitely improved it decreased the caseloads overall and really improved the balance of caseloads that people have. Because I do think it's at least possible that there were some counties where, like, I have one attorney that I trust to do murders, and so he gets all my murders, and they count for the same as a a minor drug dealing charge or something. And so at least that kind of got reformed out, which is good. In terms of incentives and everything, nothing changed. So it was just kind of we're going to continue paying the same amount for the same cases. And so there was no additional incentive to kind of undergird a more drastic change. So that's where we're at now. It may change in the future. We have made some minor adjustments over the years, but only kind of things like sanity checks in terms of like we originally, I believe, did not have a separate standard for like life without parole appeals, and now we do, like that sort of thing, and obviously more stringent. But they're very minor changes that have been made since this rolled out. I think that's everything. So I'll pass it off to Alyssa.
So we heard that New York has some caseload standards for criminal and family. Both were the Delphi process in terms of using time tracking, time sufficiency, and then a Delphi panel, in-person panel. But that's not really the exciting part of what we do. So we got the standards, and then what do you do? So first, we did a projection in 2017 for the number of criminal attorneys that would be needed as a result of implementing the 2016 caseload standards. We then redid that estimate in 2021, which was incredibly difficult because, as I'm sure everybody here knows, we kind of had a pandemic in 2020. So if you're using the previous year's data, your estimates are going to be probably inaccurate, but we did the best we could in 2021 and 2022 to produce those estimates. And then we gave those to our team attorneys. So that's how we figured out and assessed the need. However, we also here at we call it ILS, the New York State Office of Indigent Legal Services, ILS, we are required to routinely reassess caseload standards. And so currently we recognize that the 2016 standards are out of date and don't really align with current criminal practice. For instance, we had a bunch of discovery reform that had been rolled out. And since 2021, we have attorneys spending a lot more time on evidence review and discovery review. So we kind of realized that, okay, this probably needs to be updated. So what we're currently doing is we're exploring, collecting data, and conducting analyses so we can make the most impact with updated standards, at least in New York City. In addition, we're also looking at our appellate caseload standards much more closely. However, that's really all I can say about that at this moment. But the fun part of this always has been implementation. And so we have 3 ways of doing things and working with our caseload standards, because we're New York. So for the counties that were involved in the lawsuit, so there were 5, as I said, we do what's called a caseload target number. And so what that does is it assesses the staffing patterns in each of those provider offices, and it also then compares those staffing numbers to what the number of cases that have been taken throughout the previous year. The person who does this on our team, her name is Ume Tavasam, and she then sends all of these caseload target numbers to the providers for an in-depth conversation about if their staffing patterns have changed, and if so, does that caseload target number change? And the target number essentially is the estimate of the number of misdemeanor equivalent cases that office can take for an entire year. To then assess if they are on track with that caseload target number, we get caseload level extracts quarterly. So myself and Ume Tavasam, we actually look at those caseload extracts on a quarterly basis, and we say, okay, if the number is 1,200 cases per year, then you should not be taking more or being assigned more than 300 misdemeanor equivalent cases per quarter. Once we see you going over that 300, we alert the attorneys who work specifically with those counties, and we say, hey, they're going a little bit above caseload standards. Was there a change in staffing that allows for this to happen? If not, how can we start moving some of these cases to an overflow plan for the assigned counsel programs? Because typically the assigned counsel programs have more capacity than the institutional providers. So that's how we handle and address caseloads in those settlement counties. If you're not a settlement county and you're just a statewide county that handles criminal cases, we get an aggregate number of cases that fall within each of the caseload categories for the previous calendar year. One of our other senior research associate, Caroline Kalpers, is on this call. And so what she does is she then looks at the staffing that they have reported, and then compares it to what they had previously accepted for the prior calendar year. She then flags each provider office and says, hey, they took too many cases, they didn't take enough, or they could have taken more cases, and does some calculations there. She then provides all of this in an appendix that goes in our annual data report, and we alert the attorneys in our office who are responsible for budgets, and we say, hey, they were taking too many cases. Are there additional funds for an additional attorney? And then we get into the why an attorney hasn't been hired. It might be due to the fact that it's a very rural place and nobody wants to work there. It might be because the starting salary is not high enough. It might be, hey, we've hired people, but the county civil service process is just really cumbersome. And so we try to figure out why they might be taking too many cases. And if they are, we do strongly recommend these overflow programs to overflow cases to the assigned counsel programs. And those have been instituted in many counties and seem to be working pretty successfully. Finally, for family court, we are just now having provider offices report cases in the caseload categories from the caseload study back in 2019. It's been about 7 years. Yes, I recognize that. And we are just now getting somewhat consistent data from people who are getting, or from provider offices who are getting funding from us. However, it's really difficult because for criminal court, we have 7 people that are dedicated to ensuring caseload compliance and compliance with the tenets of our settlement that I discussed previously. For family court, we have 1 person. And so for her trying to flag and work with the attorneys, it's just not feasible. And she doesn't have enough hours in the day, let alone hours just on the job to do this. And so she presents those to our counsel, who then works with our director to allocate new funds as we get them based on what the caseloads look like in those counties. So for instance, she had just created a report. She was able to flag the top 5 counties that are on fire, and those counties will be getting additional funds specifically dedicated to caseload relief. I think it's like $1 million. I'm not 100% sure, but they're getting some money to hire these new attorneys. So like I said, we do things differently based on if you're in criminal court, family court, or if you're a settlement county. And Matthew, it's your turn.
We at DPD, we do involuntary civil commitment as well as dependency law, but I'm just going to focus on criminal practice with this time. As I mentioned earlier, the WSBA, the Washington State Bar Association, adopted a sort of case weighting in March of 2024 to begin in June of 2025. And offices are, structured differently. At DPD, we have a lot of independence. It's sort of drafted into our charter, which is like our constitution, our local governing document. And so we have independence, and that includes interpretive independence. And so we interpreted our code to say that we had to follow the WSBA standards. And so that gave us basically 15 months lead time. And thankfully we had IDRA member and tech whiz Steb Wiedlich on our team, who helped us roll out basically a new case management system that would allow us to automate a lot of the sort of debits and credits and the things that you really need to be able to scale to do case weighting sort of like efficiently. And so that took a long time, and that allowed us to do modeling. And because we're in the executive branch, we're working with the executive's office, and we're explaining to them sort of why, like, what are the inputs. To Alyssa's point, like, are we using 2023 data? Probably not. Are we going to use a 2-year trend, 3-year trend, 2-year average, 3-year average? These are things that you have to answer, right? And you do that in partnership with the exec, so they trust the qualitative value of the modeling. And we really tied our staffing needs, which I already alluded to are quite large, to the PAO's filing decisions. And we made that very clear, because our staffing is just a product of the staff. This is how many cases they file. This is the different case weight tiers for these cases. That's how many attorneys we're going to need. And so it really shifted the blame to the culprit, which is the PAO making these decisions. And so council, obviously, like, when we adopted these standards, they knew it was going to come with the price tag. But we explained that the price tag is going to attend any decision. Either you pay up front so we can have the attorneys and we can do what we've done and take all of the cases, or you're going to refuse cases, and then the ACLU's here, and then you're dealing with the reputational damage. There's all these other hits. And so if you work at government, litigation costs are real and oftentimes outweigh just the marginal cost of increasing staffing. And so once we did the modeling, we got the buy-in from the exec, we got the budget, we marketed like crazy. I know we have folks from all over the country. You get the bar news in your state. You probably saw an ad from DPD at some point, maybe 6 months ago, because we were doing outreach. And because of that, and I shit you not, but over like a 15-month span, we hired over 100 lawyers. And over half of them were lateral attorneys, from most of whom are from out of state. And they were coming because they were attracted to this new case-weighted model. Like, we weren't there yet. It was still going to be a timeline, but just the promise of being able to be a part of something that was trying to get somewhere where it's sustainable. Still hard. The work is always going to be hard, but at least sustainable, attracted a lot of people, and we've kept them. Our attrition rates went down, our hiring went up, and we started this experiment in June of 2025. That's when we started phase 1. We're a week away from finishing our first year. Everyone has stayed under the caseload limit. There's things that we're going to tinker with before we go out to year 2, but it's worked. And so we got the buy-in from the exec's office. Council knows that there's going to be costs. We've been able to take all of the cases. We've been able to stay out of the news, which is increasingly hard these days. And I guess the thing I want to emphasize is that we put the burden on the PAO and put the pressure on that independent elected person to justify the filing decisions that are costing the general fund so much money. And so I know I spoke fast because I had a lot to say. Happy to follow up.
Thanks, Matthew. Yeah, I'm going to try to move through this quickly also. This NLADA report came out basically slamming what was happening in the state. And from there, a couple of really important steps happened. I also noticed this morning that this last thing says 2014 on it. It should actually say 2024 to make this timeline make sense. So on the heels of the NLADA report, the then governor established the initial Indigent Defense Advisory Commission, who then called for a permanent Indigent Defense Commission which was signed into law in 2013. I'm going through all of this because I think that it's hard to, in Michigan at least, to think about caseload standards outside of this entire package of reform, because it really all moved together and at the same time. And so, like I said before, our first set of standards were implemented in 2019, which again was the first time that state dollars had helped fund indigent defense in the state, and also was the beginning of oversight over the local systems developing or delivering services. And so, even though our first standards were implemented in 2019, our workload standard did not get implemented until 2024. And that is because we rolled standards out gradually rather than all at once. And so that standard came a little bit further down the line. Sarah, on to the next slide. And so our workload standard is standard number 6. What this says is that the caseload of indigent defense attorneys shall allow each lawyer to give each client the time and effort necessary to ensure effective representation. I won't go through the whole thing, but of note, what we adopted at the time of the standard was the levels that were suggested in the 1970s by NAC. That's 150 felonies, 400 non-traffic misdemeanors. But at the same time, what the standard also said is that workloads needed to be determined over time through Michigan's specific weighted caseload studies. And so, the standard was written with these numbers, but also with an indication that it needed to also be made more specific to Michigan at some point. Sarah, on to the next one, please. And so it's been kind of an interesting timeline here if you think about the way that these things have moved in all of the states that are and also counties that are here today. So in 2013, the Michigan Indigent Defense Commission Act was signed, and the commission created. That act really very specifically lays out what the standards need to address. And one of those things is attorney workloads. And so in around the 2016-2017 time period, that standard was getting written, the standard that I just showed a part of. And then between about 2017 and 2019, we moved forward with doing a Michigan specific caseload study. And that is, very similar to what you all have shared as well. And I saw also Nick Pache on the call who led the study in Michigan. I also saw Cynthia Lee on the call who, really has helped me many times over the years in thinking about what these standards look like. And so, RAND came back with these numbers, and the numbers were much lower, not surprisingly, than the NAC numbers. And I remember having a conversation with Nick and saying, before the numbers even came back, and he said, when you get these numbers, they're going to be a lot lower than what you currently have. And I said, okay, and then how do we kind of translate that into policy and practice? And he said, well, that looks a lot of different ways in a lot of different states. A lot of times it can be used as kind of a bargaining chip. A lot of times it's, just a piece of information to have to use in the future. And that was right. So, we got these numbers back around that time, 2019, went back to revisit the standard in 2020 and 2021, and knew at the time that there was actually going to be very little support for moving forward with such a steep decrease in workloads. Moving to the standard as written, the 400 and 150 numbers, that was already going to be a dramatic decrease in caseloads in Michigan, and also a dramatic increase in cost. And when packaged with the other standards that we were implementing, we were talking about hundreds of millions more dollars every year going into indigent defense than before. And so, despite having these RAND numbers that were lower, we did end up still implementing Standard 6 as initially written, which was the 400, 150 numbers. And then right as the standard actually went into effect, the National Public Defense Workload Study came out, which was, really validating of these RAND numbers, because it in fact was even lower than those RAND numbers. And so, I think, and I'll talk a little bit in the next part about what's worked and what hasn't worked. I think it's been really useful for us to have those numbers. They can be used as a bargaining chip in moments, both by local systems and by us. And we will continue to move towards them. But I think that even though weren't able to implement them right away, they have still been really useful to us. So I will pause there.
Okay, great. Well, we are going to move on to our last two questions. And the first one is, what is working? And since I want to save time for questions, maybe if our panels could go a little faster, take a couple minutes to highlight what is working, and then we can give our folks that are here time to even ask questions about what is working more. So again, we're starting with you, Torrin.
Yeah, so mine can go really quick because I essentially said all this in kind of the implementation because really, we we were able to implement new caseload standards that made more sense, at least, even if they weren't as stringent as maybe they should be. And we didn't blow up the system, nobody left, and we kind of were able to continue with this as a new baseline. And without the only kind of pushbacks that we've had against it are not really specific to this caseload change. It's more like I can't find any attorneys, and we would have been having the same issue, I think, even if we hadn't adopted the new system. So I think overall it was a wholly positive change, even if it could have been better. And that's all I'll say on it.
I can make this quick too as well. Criminal court, we do great things there. We had a lawsuit. We love it. We had, and as Matthew, his language was, the lawsuit gave us teeth. And then we had New York State, who actually committed funding to hiring staff, and that wasn't just provider office staff, that was ILS staff as well. Just like I said, our family court person can't do everything. We have 7 people dedicated to criminal court representation. Finally, what is working is the level of oversight we have because of the lawsuit, because of the expansion, and because of the funding. We work with counties to create these plans for caseload compliance, which allows us to assess the need for additional attorneys on like a rolling basis kind of, and case management systems, so that way providers can report data to us better. Because sometimes if you have caseload standards, as I'm sure many people here know, it doesn't always get categorized correctly in the right bucket. So you might have something that is a post-disposition case. That's something that happens that should only be weighted as 1.5 misdemeanor equivalents, but how it's being put in the case management system, it ends up being 9 misdemeanor equivalents. And so having those relationships with not only the providers, but the vendors of case management systems to accurately capture what providers are doing has been working. And like I said, building these relationships because of the oversight has been working and has been incredibly helpful.
Okay, so what's worked? As I mentioned, we've hired over roughly 100 lawyers in a very short period of time, and this wasn't just every person with a bar card, right? These were either like very highly sought after law students, former clerks, or experienced attorneys from other states, and those are, as I think we all know, some of the hardest attorneys to recruit, and sometimes the ones you need the most, because you need folks to take those serious cases because it takes years to develop them. And that's something we've learned, is it just takes years to cultivate the talent within your system, and so to find those laterals, that's a challenge that I think everyone will face. But that our policies worked. We're at a year. It's held up under load. It's scalable, and we think the policy is one that should be attractive to local governments, because you put in your inputs and it will tell you what the costs are going to be with reasonable accuracy. At least it did for us. And the thing that I would say hasn't worked, and I want to emphasize, is that for all the wisdom and strengths of the National Public Defense Workload Study, it didn't answer the question of professional staffing. And the question of, as you give attorneys fewer cases, of course it's going to impact work downstream, it's going to impact the work of investigators and suspects, but how? We haven't found a way of measuring that. It surely can't be ratios. There's been some approaches that say a ratio, but one can imagine getting assigned 3 attorneys who do a lot of investigation requests, and meanwhile another 3 who are in a practice area that doesn't call for it. And so we have reservations about such a simple sort of strict ratio standard. And so one of the things that we're working on in the coming year is taking our data and actually trying to adapt something like a workload study, but for professional staff. And if you all are working on stuff for professional staff and staffing to make sure you have the support, I'd be interested in hearing your approach.
All right, on to Michigan. It was really helpful to think through these two questions, actually. And so I've come up with a couple of categories of things that worked. So three main things. The first one was adding some nuance to the NAC numbers. Now, we haven't been able to add nearly as much nuance as we would like, nearly as much nuance as was in the RAND study or in the national workloads report that came out more recently. But we did add a little bit of nuance. And so things, for example, like not just having those two categories, but also shifting traffic misdemeanors, probation violations, and contempt cases into their own category. And also for systems that use House Counsel or shift coverage models, which is very popular in Michigan. House Counsel a little bit less so, though popular in a certain area of the state. And shift coverage very common, especially at the arraignment stage across the state. So, every hour that is worked on a shift, just meaning you are at the court responsible for whatever is happening in the courtroom at that time, every hour proportionally reduces the number of hours available for case assignments. And so, that's really critical because even though our standard only speaks to case assignments, we have to make sure that we're actually accounting for the workload in its entirety. The second thing, again, like I said, reckoning with the RAND results. I think that what has been really good here is that our standards are called the minimum standards here, meaning that they are a floor and not a ceiling. And so when local systems come to us each year with their budgets and their plans for the following year, several have come forward and asked for more attorneys at their public defender offices based on the RAND numbers. And so, several systems have made the choice to kind of move ahead with that and staff differently, not just based on what the standard says, but moving beyond that to a Michigan specific study. Budget-wise, I guess it's good that we've only seen that from a couple systems at a time. But I think over the years, we will see more and more of that. And then putting out a ton of instructions and trainings for calculating caseloads and logs for tracking. So it's only one line on my slide here, but actually it should probably take up my entire presentation. It has been constant, it has been challenging, and it has been a little bit shocking how difficult it is to help local systems track caseloads, and not even necessarily what to do once attorneys max out over their cap, which is a whole other presentation, but just the actual tracking itself. I think I had no sense prior to this of just how much time and work we would be putting into these things we're a full year into implementation, but really kind of moving towards it for 2 years. And, we're still having conversations about how to properly count cases, what sorts of software they can be using for tracking, how to report that to us. I mean, it is just kind of like a daily practice. My entire job basically in the last year has turned into a standard 6 job. I would say we have all that on our website. I'm happy to drop a link into the chat if anybody's interested in seeing what some of those templates look like.
I was going to say, could you do that, Jonah? Because our director, Melissa Mackey, in New York is actually giving our first in a caseload standards calculating curriculum. So we would love to see that if you would drop it in.
Yeah, absolutely. I'll drop a kind of the umbrella link, and then in it you'll see lots of different things, like kind of some FAQs, and then also spreadsheets, templates, instructions for using them, all sorts of things. So yeah, I'll drop it in a moment.
You had a few more slides, Jenna. Did you want to go through any of those, or are they all related?
Good question. Yes, I do want to go through them. I forgot about them. Thank you. I'll just run through them quickly. So in terms of just giving you a sense of what some of these templates look like, so this is just the most basic spreadsheet that we have offered to systems to think about their tracking. And so these all just have the formulas in them. to properly calculate proportions and such, because of course it is very unusual that somebody only is taking cases in a single category. And so, they can put their attorneys in, and then they can put their assignments in, and they can figure out, okay, with this combination of cases, it will automatically calculate for them what percentage of their cap that they're at for the year, and then also the maximum number of cases left that they could take in every one of those categories. So I just put some random numbers in here to see how the numbers change as you put things in. And then, of course, docket hours in here as well, because it's not just case assignments that we care about, but also docket hours. And I think there are 3 different types of spreadsheets on our website that systems can use depending on how they want to think about it or what matches up with their own internal tracking best. They don't have to use any of them, but most of them are using them. And our research analyst who's not here today, Neil Weinberg, he has also spent quite a bit of time helping local systems customize Excel spreadsheets for, again, to fit what they're already doing. It's very challenging when our system is so decentralized, like many of the other systems who are on the call today. Bob, let me pull up your full question. Hi, Bob. Yeah, so when does the commission plan to implement the RAND numbers, I think is what Bob is asking. I don't know. We have moved into a little bit of a budget crisis in our state in the last year. And I think that for the first time, we have really felt a lot more pressure around how much money is going to continue to be made available for indigent defense. We still do not have a dedicated funding stream here in Michigan, and so it's just general funds. And as we have implemented all of the standards, we are now costing the state quite a bit of money every year, increasing, moving further toward the round numbers. It is only going to bring that number up more. And I think, we're doing a little bit of reconciling with local systems and what their spending looks like and what our current state budget crisis looks like. So, I don't know, to be honest. I think it is not a conversation on the table right now. It will be in the next couple of years, but I don't see anything moving on that I would say 3 to 5 years, probably at the earliest. And then Sarah, if you want to just go to the last slide. So just, in terms of tracking and feedback. So like I said, we're about 1 year into full implementation. We're doing careful tracking of attorney workloads at the state level. We're getting lots of pushback from local system administrators about attorney shortages and lack of qualified attorneys present to take cases in the county or in the city. We're getting, not surprisingly, a lot of support from salaried public defender office attorneys whose caseloads have decreased, but also pushback from attorneys who feel like the standard has decreased their capacity to earn a living to, take as many cases as they want. Yeah, Bob, I think that's right. We are an example of big state funding. And it's not unlimited. And also, this is a little bit off topic, so I'll just be very quick. But, in response, what we have seen over time is that systems, they submit these budgets to us every year. We take the budgets, we ask for the money, and then, we reimburse. And every year there are large sums of unexpended funds. Systems, which, in many ways is not surprising, right? They want to make sure that they have what they need. So they over budget a little bit. There have also been new standards basically every single year until this past fiscal year was the first time that, we didn't have a brand new standard. And so, now that all the standards are really in place, it's time for us to right size a little bit, but funding wise. And so, we're really going to be shrinking down, hopefully not on what they need, but just kind of cutting the extras. And once we are able to right size a little bit, I think that there will be more space to continue pushing on these caseload standards. But I think that right sizing has to happen first. I'll pause there, Sarah.
Okay, great. We're through our last question, which if we keep at the same pace, you guys did great. We should be able to have plenty of time for questions. I should have maybe ended on the positive with what worked, but I'm ending on the negative, what didn't work. And I think that's probably because we're just most curious to, it's not just what didn't work, but what lessons have you learned? what have you pivoted? What have you had to be adaptable? As you've been kind of working through this as well. So we'll start with you again, Torin.
Yeah, so I'll be very quick. So I've already said I wish it could have been closer to the standards that actually came out of our study. But forgoing that, I do wish maybe there could have been like a on paper, these standards will be reevaluated at this date or something like that. I know why we didn't do that because I think there was a lot of anxiety about that being the case, that like this was just the first salvo and we're going to have to do this every year and we're not going to be able to handle it. And so I understand why that didn't happen. I think that anxiety might have gone away once the first rollout actually happened, given that we got very little pushback on that first rollout change. But you know, who knows? Maybe it would have been worse than I'm imagining. And then the other thing is stuff that's been touched on by both Jonah just now and Matthew. There's a lot of like our case tracking system is cases assigned to attorneys, and one case gets counted once. So if there's a transfer, then we just we either move the case over to them or it stays with the person that had it, depending on how long they've had it for, and that's obviously not ideal. There's a lot of things attorneys do that aren't directly cases assigned, like shift work, like Jonah said. We don't have that very much, except for the case of counsel at first appearance, which is something that we're looking at trying to track. But right now we're just in the like get them to tell us that it's happening stage, not doing any kind of standard. Our drug courts and our problem solving courts in general are essentially enforced transfers, because generally that gets assigned to an attorney, that attorney successfully gets them into that program, and then it goes off to the attorney that's dedicated to that program. And how do we track their cases? We don't really have a great answer for that right now. And things like that. And I think those things are going to continue to increase in terms of the things that attorneys are doing that are not direct representation for an assigned case, that currently our system does not handle. But I'll leave it at that.
So obviously, what doesn't work, not having funding. But there's two things also that do not work. And I might get fired after I say this. I apologize, Melissa, for going rogue. But also there needs to be a discussion about a lack of a strategic plan. As I've highlighted here, we have 3 different ways of evaluating caseload standards for 3 different types of representation or settlement status. And at the time, it was, let us address the current problem, which is the settlement counties need to have their caseload compliance assessed. Okay, now the statewide counties need to have it assessed. And so that has led to inconsistent requirements and inconsistent reporting requirements. That also means that as the research team, we do not have the same level of information to make as detailed or as good of decisions. So for instance, like I had mentioned in the Harrell-Herring counties, the settlement counties, we get case level extracts that tell us exactly how the case was entered into a system, and here's how it is counted, and here's the disposition. But for the statewide counties, we don't have that. And so that has actually kind of limited our ability to really fully assess caseload compliance within these different counties. Kind of sounds like an equal protection issue to me, but I'm not the lawyer. And so that, I think that in government, I think most of us can agree that there's always just this need to solve the current problem, but there isn't a need to look forward and do strategic planning. And I don't know necessarily what the solution is for that. I mean, if you have more time to implement these things, then I would highly suggest actually sitting down with whoever the decision makers are and figuring out what assessing compliance looks like in many years. The second thing also is making sure that if you're going to be making decisions about people and their work, making sure that you include those people in the discussions. As Matthew had said, in Washington, they are learning, or they're trying to figure out how to count specialized services staff. That's at least what we call them in New York: investigators, social workers, paralegals, secretaries, all of those things. And if you're not including those individuals in the discussions, then you really shouldn't be making decisions about them either. And so that also applies to data collection, data analysis, because if we had that strategic planning where the people who were collecting and analyzing the data and reporting and working with the attorneys, if those people were involved, then maybe we could have had a better strategic plan moving forward. Because sometimes, we get asked questions like, hey, what does caseload compliance look like in this county? Well, I can't really tell you because we don't get the same level of information. Well, why don't we? I don't know. I wasn't involved in that conversation. And so for those who are implementing caseload standards, I highly encourage you to, number one, develop a strategic plan for how you will roll them out and how you will assess compliance moving forward, but also including all members of the staff who are responsible for implementing those caseload standards. That's what I think would be better and what hasn't necessarily worked. Finally, for those who work with assigned counsel programs, as I'm sure you know and have been beating your head against the wall for many years, getting independent contractors to report is incredibly, incredibly difficult. We've had some successes here in New York. I was just on the phone with an administrator yesterday who said that she has actually gotten buy-in from her county to now let the attorneys bill 1/10 of an hour and 2/10 of an hour for filling out data collection forms and for putting things in their case management system. It doesn't sound like a lot, but hey, $15 over like 100 cases a year. Like, I mean, I wish I was in a position to turn down money, but I guess some people are. And so figuring out how we can get these assigned counsel program attorneys to not only just report, but report consistently, that would also be great. So if you have any suggestions or how that's been working for you, please get in contact with me because it is a very big issue we're working on right now in New York.
Thankfully, this year is like our first year officially doing the case weighting policy as like a mandate, but we did like a pilot year the year before to kind of test out the case weighting because we were just moving from like a prospective system to like a completely different paradigm shifting model. And so there was a lot of challenges, a lot of kinks to work out, largely the biggest one being transfer cases. What do you do with the existing caseloads? Maybe you don't count those, but people are going to leave and these cases need to be shifted, and those are going to be new cases from the standpoint of the person receiving that case, and to say that they don't get any credit for it kind of flies in the face of the work we're expecting them to do on those cases. And so we had to do a lot of tinkering with our modeling to allow for extra credits for transfer cases, but still keep it within a range that we could account for and we could measure out. The biggest challenge, not the biggest challenge, but one of the things that we're going to have to emphasize is the timekeeping requirement. So we've always done timekeeping at DPD, but there was historically like an incentive to put the time in because you would unlock supplemental credits as you cross these gates. Now, because of the presumed credit hours, that incentive isn't there, but we very much still need this data because the fidelity of those numbers are going to be relied upon to make other staffing decisions in the future. And so really just kind of shifting people's perspective on the value of keeping like very accurate case-related time entries is a challenge. The gentleman from Indiana pointed out that a lot of the work we do is not case-related but still work, and a lot of the data we need is case-related. And so trying to figure out a way to capture that, but also account for the not case-related work that is nonetheless work. Are some of the challenges. I would say the biggest thing that has not worked, though, is that we have not succeeded in getting the state to pay its fair share. As I mentioned, Washington State is in the bottom 10% in terms of what it pays for public defense at this trial level. The burden is disproportionately borne by local governments. And so we haven't shifted the needle there. That's why we're in the lawsuit right now, DPD specifically, suing the state with other counties. And we haven't succeeded in getting the separately elected PAO to reimagine its filing practices. I think that lawmakers, I think executive officers, they see that there's clearly a relationship between filing a bunch of low-level felonies and increasing the cost to the general fund for public defense. But as a separately elected prosecutor, the motivation isn't really necessarily there, right, to be more cost-effective in your filing practices. And so trying to find a way to get the PAO to recognize the value and sort of reducing filings is an ongoing challenge.
Great. Okay, so what did not work in Michigan? The main thing is, the lack of centralized workload data between systems. I think Torrent, somebody mentioned this earlier, I think Torrent is, it's one thing to keep track of attorney workloads when they work in a single state, or sorry, in a single system. It's much different to keep track of attorney workloads when they are working in multiple systems, and some of the attorneys in the state work in quite a few. And so, the standard as it was originally written, we have no centralized data system or case management system here. And as originally written, the standard contemplated local administrators basically figuring that out themselves. So whether they're asking attorneys to report their workload from other systems, or whether those administrators are in touch with the other administrators to be sharing information. And it quickly became apparent that that was not going to work. It was not going to work because lots of attorneys don't do a good job keeping track of their caseloads, especially when they are taking caseloads in many different systems. And it was not going to work because, because of the web, administrators reaching out to other administrators would basically be sharing it would be like an infinite number of loops, as they spoke to all the different attorneys that had, or sorry, all the different administrators who had different attorneys in different spaces. And so we started piloting with the monthly collection of workload data through the MIDC, from every system, aggregating the results, and then sending them back out to local administrators, so that they could see what their attorneys were doing across the state. We've been slowly building that pilot, and just brought in our last two regions this last month. By October, so the beginning of next fiscal year, that will be happening across the state. And I think that, I think it's really the only way to actually get reliable data out to people. I'll move quickly because I know we're getting late. The second thing that's been hard, again, and this is not unique to Michigan, is the attorney shortage, especially in rural areas. Michigan's current response to that has been something called the Michigan Special Assignment Team, which is not run through the MIDC, but it is funded by the MIDC, and it is an organization that basically pairs attorneys to cases in other parts of the state that need assistance, whether they're just kind of low on attorneys generally, or whether they are low on attorneys with certain qualification levels. So maybe there's, a murder case in a rural area. They only have one life qualified attorney, but that attorney is already, overloaded with cases. So they're gonna bring in somebody from the Michigan Special Assignment Team who's maybe from from Wayne County, from Detroit, wherever, where there's lots of attorneys, and bring that person, to represent on that case in this rural area. It's been a pretty effective solution. It has been a highly ineffective solution cost-wise. It is not, really not feasible for it to be a long-term solution, but it is patching some holes in the meantime. And then the last thing I put under what does not work is how do we factor in other work that is not adult criminal indigent defense to our standards? And the answer is we're not dealing with it right now. So I was, just a really ardent supporter of bringing that in from the very beginning. And it just, was not possible. I'm not sure when that will be brought in, but, yeah, we're not addressing it yet.
Okay, so we got through our questions. We are running out of time, and I want to respect people's time. So if anybody who does need to go ahead and log off, at the hour, no problem. I will ask everyone to kind of put their contacts, if you feel comfortable sharing, in the chat. But I do want to thank, before we open it up to questions, I do want to thank Torin and the Indiana Commission for Court-Appointed attorneys. I do want to thank Alyssa and the New York State Office of Indigent Legal Services. I do want to thank Jonah and the Michigan Indigent Defense Commission. Of course, Wesley and the IDC, and Matthew in King County. Thank you so much for sharing your wisdom with us. And now I offer their wisdom to any who would like to ask a question. You may raise your hand, type it in the chat, whatever's easiest for the group. Does that sound good, Torin? Thumbs up from Torin.
So there's one in from Nicholas. We'll go first come, first serve. That seems fair. When measuring attorneys' caseloads, how do you square the RAND study's work hours per year and the blunt instrument measures of appointed or disposed cases within a year? For instance, if looking just at appointed cases, if an attorney already has a lot of felonies, you might not want to assign another year's worth of felonies in year 2, since felonies often take multiple years to be disposed. Do you have a measure for tracking working caseload or use time tracking? So I'll quickly answer for myself. This is an area where we don't do very well, other than we do a rolling 4 quarters, so it's not like, you can give someone 100 cases on December 31st and then 100 more on January 1st. But in general, yeah, we don't handle it super well. Is my answer. It's assignment based.
I would say we're the same way in New York. We do collect data on pending caseloads, so at least we do have that in the aggregate. However, at ILS, our approach is to usually let the providers run their office, and so if they have seen that maybe someone does have too many felonies, then we tend to work with them from a provider office standpoint. They can assign though as they see fit, and that's just a position that ILS has taken.
That's an excellent point, and it's something that we are noticing. And so one of the data points that we track are open caseloads, and so we see whether or not how a person's closing cases relative to how many cases they're receiving, to see if they're trending in one direction or another. And there could be multiple explanations for that. So we would want to know whether or not the outcomes are also different and kind of look back. But ultimately, we try not to operate at capacity. So when I say a felony attorney's capacity is 99.7, we don't want them to be at 99.7. And so ideally it would be closer to 80 or 85, and that wiggle room gives the supervisor the discretion to kind of assign cases as they think as appropriate, taking those other things into consideration. Which I know isn't a perfect solution, but
yeah, I would echo what's been said, especially from New York. We operate with these standards being a floor and not a ceiling. And so, we always encourage local offices or administrators to be thinking about these things as they're making assignments, and to not necessarily be keeping somebody right at 100% of their cap, but to be watching it over time and making assignments as appropriate. We are not tracking open caseloads, though I know that many of our offices are, and I hope more will continue to start doing that.
And I think we saw a hand up. Is that right?
Cynthia, I don't know if she had to run though. Oh no, Cynthia's still here, but maybe we addressed it, but feel free to unmute.
Yeah, I was just going to comment that the arithmetic behind the national study is designed to work on the basis of incoming cases. And if you want to be tracking instead pending cases, there are some adjustments that need to be made mathematically. And it's too complicated to explain in this amount of time, but if you're interested, please feel free to reach out to me at the Deason Center at SMU.
Well, we are past the hour. I'm happy to stick around for a little bit longer, but I think we can have an official end if that works for you, Sarah. Okay,
that's great.
We'll have an official end. I'll end the recording, and then stick around for another few minutes in case there's a couple other useful conversations to have.